Hello, and welcome to Itentive's webinar on medical records and minors, navigating parental and patient rights. This is the 6th installment of our weekly webinar series, and we hope you find it thrilling, or at least interesting and beneficial. My name is Chelsea Lukens, and I'm the Marketing Communications Coordinator for Itentive. I would like to take a moment to explain the process for today's webinar. First, I'd like to mention that this webinar will be recorded. Next, I'm pleased to announce that our next webinar will be on February 11th, covering Meaningful Use Relaxation Rule. Are you relaxed? We hope to see you there at noon Eastern Time. At the end of our presentation, we will open the floor up to questions from you. We will answer all the questions at the end, but you may type them in the questions area of the webinar control panel whenever they occur to you. Finally, for audio clarity purposes, everyone's phone will remain muted throughout the entire webinar. If you experience audio issues, please use the chat box to let us know so we can resolve them. And again, questions may be entered in the questions box. Finally, I would like to introduce our presenter for today. Cynthia Kincade is Vice President of Consulting Services at Itentive and a Certified Practice Management Executive. With over 25 years' experience in the IT healthcare industry and 8 years with Itentive, her experience runs wide and deep. She is not only a senior executive at Itentive, but she lives and breathes the industry and travels across the country seemingly nonstop, working with our clients at their locations. This makes it possible for her to provide the insight needed to help healthcare organizations experience great success, no matter what the challenge is. Cynthia, I'm going to go ahead and pass the webinar off to you. Feel free to get started when you're ready.
All right, everyone. Thank you, Chelsea, for that nice introduction. I would also like to call out Adam Boren and Nori Butt, two of our implementation consultants who worked very hard with me on this presentation, and particularly in the research areas of the laws and regulations. We're going to be talking about navigating parental and patient rights. This is a very tricky subject in today's healthcare, particularly with all of the EHR and access areas. The first thing we want to talk about are medical record guidelines. Establishing general guidelines for your practice when dealing with minors and their rights can be complicated. Knowing which laws apply to your patients are not always clearly stated through the state revised code. Parental access to minor records. Medical record access for minors and their parents are defined predominantly on the state level. For minors under the age of 12, most states allow full parental access to medical records. For minors between the ages of 12 and 17, the parental rights to access to medical records depends on the type of treatment the patient is receiving, and it gets really fuzzy, and it varies from state to state. What we decided to do when looking at this is we decided to look at the laws of 3 states on how they define accessing minor medical records. We chose Ohio, Illinois, and New York simply because we have a number of clients there and we have worked very specifically in those states, as well as many others. However, these 3 seem to give us a wide breadth, with Chicago and Illinois, New York having obviously New York City, and Ohio being a large, a Midwest area and a high university area. If there is not a state law, the licensed healthcare provider may exercise his or her professional judgment to the extent allowed by law to grant or deny parent access to the managed medical record. This gives a lot of responsibility and judgment leeway on the side of the provider. So when can parents not access the minor's medical record? We chose the word not as opposed to when because this is typically treatment-based. So when the minor is the one who consents to care and the consent of the parent is not required by law, if the minor obtains care at the direction of a court or a person appointed by the court, when the parent agrees that the minor and healthcare provider may have a confidential relationship. These bullets are based on the federal standard privacy rule. The privacy rules defer to state or other applicable laws if the state has more stringent laws. So in other words, you must meet this minimum. However, if your state has more stringent regulations or more lenient regulations, the state actually trumps the federal. Records that cannot be viewed by patient-authorized representative. If a parent or personal representative cannot by default view the medical records of treatments consented to by a minor without prior consent from the minor to release these records. These examples of authorized representatives are the parent, healthcare power of attorney, court-appointed legal guardian. Those are the 3 that have the ability if the consent has been provided. And in these cases, we're going to be referring to this a lot as we go through these slides. What records can a parent not view for a minor in Ohio? So we're going to start with Ohio. A parent or personal representative cannot by default view the medical records of treatments consented to by a minor without prior consent from the minor to release these records. And slide 6 is what the personal representative consists of. So how does Ohio define a minor? In Ohio, a minor is a person under the age of 18. Generally, people under age 18 minors must have the consent of a parent or guardian before receiving medical care. However, there are several exceptions to this general rule. A mature minor exception. In Ohio, a mature minor is someone over the age of 15 who can show a health care provider that he or she has enough maturity and understanding to make medical care and treatment decisions without parental consent. On a case-by-case basis, the health care provider uses the same criteria that he would use to determine if an adult is capable of making medical decisions. If the minor is found capable of consenting, the health care provider must give the minor the same informed consent an adult would receive. There is also emancipated minors. Ohio law does not specifically define an emancipated minor. However, according to the common law that comes from cases decided by judges, a minor who is no longer under the protection and control of the parent or guardian is considered emancipated. An emancipated minor would generally include someone under age 18 who is married, is in the armed forces, is self-supporting, and is living away from the parent's home. An emancipated minor is usually considered capable of making medical treatment decisions. The types of treatments a minor can consent to in Ohio is limited outpatient mental health care if at least 14 years of age. The provider can notify the parents if they believe the patient is suicidal or homicidal. Counseling or psychotherapy sessions are limited to 6 sessions or 30 days under parental consent, until parental consent is obtained. These are interesting bullets, and you'll see several of these where that they can consent, but only up to a limit. So in this case, it's 6 sessions or 30 days, and if you exceed that, then you must obtain parental consent. Again, very tricky. Alcohol and drug abuse treatment, determined mature minor by healthcare provider. Testing for HIV/AIDS, if determined mature minor by healthcare provider. Again, putting that leeway with the individual provider. Family planning services, if determined a mature minor by the healthcare provider. This includes pregnancy testing, contraceptives, emergency contraception, STI testing, and treatment. Abortion services, the minor required to apply to the local juvenile court if the court finds good cause to bypass parental notification. In this case, you must have a court intervention if you are in Ohio. Sexual abuse or assault treatment. Medical treatment for counseling is determined by the mature minor by the healthcare provider. If we move on to Illinois now, and you'll see some significant differences here, a parent or personal representative cannot by default view the medical records of treatments consented to by a minor without prior consent from the minor to release these records. And again, slide 6 is where we define what a personal representative is. How does Illinois define a minor? In Illinois, a minor is a person under the age of 18. As a general matter, Illinois law requires a minor who seeks medical treatment to obtain consent from a parent or guardian. There are, however, several exceptions. The mature minor exception, the Illinois Supreme Court has recognized a common law mature minor doctrine, pursuant to which a trial judge can adjudicate a minor mature enough to consent to or refuse medical treatment where the evidence is clear and convincing that the minor is mature enough to appreciate the consequences of her actions and to exercise the judgment of an adult. So in Illinois, there are actually laws defining this, and the court will determine what a mature minor is. How does Illinois define emancipation? Under the Emancipation of Mature Minors Act, a person 16 years or older may be emancipated or partially emancipated by a court if the following items apply. Number 1, the minor is of sound mind. Number 2, she has the capacity and maturity to manage her own affairs, including finances. Emancipation is in the best interest of the minor and his or her family. A court may not enter an order of whole or partial emancipation if there is an objection by the minor, her parent, or guardian. So again, this is all by judgment and intervention. In Illinois' minor records treatment, you can consent to a patient who is a minor can consent to medical treatment upon his or her child of any age. So if the minor is in fact a parent, they have total control to consent to for their child. General medical treatment, including abortion, married, pregnant, or parents have the same right to consent as people 18 years or older. So if you are married, pregnant, and or parent, even though you're a minor, you have the same rights as anyone that's 18 years or older. Birth control services, married, pregnant, a parent, or referred for birth control services by a physician, clergyman, or a Planned Parenthood agency. So that takes it a little different direction in Illinois. Anonymous testing for HIV, AIDS, this applies to any age. Notification, if positive, will go through the parent or guardian if the healthcare provider deems this to be in the parent's best interest. So this is an interesting one because any age can have the anonymous testing, but if it is deemed positive, then it becomes the determination of the healthcare provider. Medical or counseling care related to sexual assault and abuse victims of any age. Treatment for STIs, alcohol, and drug abuse, age 12 or older. Outpatient mental health treatment, age 12 or older. Outpatient counseling to a minor under the age of 17 is limited to 5 sessions, lasting no more than 45 minutes until consent from the parent or guardian is obtained. Voluntary inpatient treatment, age 16 or older, may be admitted. Parent or guardian shall be informed immediately upon the admission. And there are a couple of asterisks. A provider may choose not to give access to records if they believe the minor is the subject of domestic violence, abuse, or neglect. Moving on to New York. Same definition. A parent or personal representative cannot by default view the records of a minor unless it is consented to by the minor, and reference slide 6 for what a personal representative is. And this is saying the same thing over. It's a little bit difficult and sometimes to distinguish these. How does New York define minors? A minor in New York State is deemed as a person who is under 18 years of age. This is defined by the General Obligations Law 1202, Domestic Relations Law 2, and Public Health Law 2504. Under this section of public health law, a person who is 18 or older may give effective consent for health care. Again, it's a little bit more specific in New York. In New York, emancipation has been defined as the renunciation of parental rights to a child. This means that parents can no longer make decisions for their child, and the child is entitled to some, but not all, adult rights and privileges, including the right to consent to one's own medical care and the right to retain one's own wages. Courts have only considered a minor to be emancipated if he or she is married, he or she is in the armed forces, he or she is economically independent through gainful employment, his or her parent has failed to fulfill parental support obligations, and the minor seeks emancipation through the courts. New York's minors' medical records. Type of treatments minors can consent to in New York. Reproductive health care. If determined mature minor by the health care provider, again, we're back to the distinction that the health care provider can make some of these decisions on their own. This includes family planning, birth control, emergency contraception, abortion, pregnancy prenatal care, including care during labor and delivery, STI treatment. Mental health services, outpatient treatment determined mature minor by the health care provider, and inpatient treatment, minors 16 and older. We have not seen inpatient treatment on mental health in any of the other states that we've mentioned. Then certain alcohol and drug abuse services, any non-medical alcohol or substance abuse services such as counseling, medical alcohol substance abuse treatment may be consented for by the minor if the parent is not available, if the parent refuses to communicate, or refuses treatment and the provider believes it is necessary. In this particular case, the parent is notified. However, you can see there are circumstances where the parent's wishes will be trumped. HIV testing. Parent consent is generally required for a minor to receive treatment for HIV. Sexual assault treatment determined mature minor by the healthcare provider. So what we did then is, after looking at these 3 states and trying to give a summary of those items just in a bullet point fashion to show you the differentiations, what we decided was to put it together in a spreadsheet. So if we look at outpatient medical care, in Ohio it's limited and it's for patients 14 years or older. In Illinois, it's yes, and it's 12 years and older. And in New York, it's yes, and it's determined mature minor by the physician. Inpatient medical care is no in Ohio, so the age is not applicable. It's limited in Illinois, and it's limited in New York. And I'll give you a second to just kind of take take a look down here, but as you can see, it varies from state to state, and knowing your state's laws becomes a critical function when trying to make these regulations and policies in your own practices. We will be providing a copy of these slides so you can take a look at this in more detail. I won't go through and read each of these items. Minor medical records disclosures, recommendations, and options. There are many nuances to a minor's medical record laws and their parents' or guardians' access, making it hard to set a clear-cut protocol for handling these instances. To further complicate it, NextGen does not have any processes set up to automate restrictions for access to the patient portal and minors and their parents and guardians. What further complicates this that we don't really have on the slide is the personal aspects to this. I'm sure each of you, if you're treating minors, understand the challenges in sharing and indicating to a parent that they absolutely do not have access to this information or that you can't give them access to the patient's information. So there are some steps you can set prior to disclosing any EHR data. First of all, understand the laws. I think if we haven't demonstrated anything, the laws are very, very critical to doing this and moving forward with this. You have to understand your state, and if you don't have laws in your state that you are clear-cut, understand the federal laws. Obtain proper consents from both the parents and the patients. Make sure they understand. Understand that these are rules and regulations that you as providers have to follow. Educate your team, and then document in the appropriate areas of both PM and EHR so it's easy for your team to find if someone is making the request. Some common practices for offices when manually providing medical records. I'm not to the portal yet, so I'm just talking about when requests come in. Both clinical and front office staff utilize the EHR to view HIPAA documentation and the disclosures of the PHI log. Make sure that you have all of the information. I'm showing just a couple of NextGen screens. However, make sure that you understand in all of the places that you document, whether it's in NextGen or in another practice management system or another EHR, make sure that it's documented and easy to find and all of your staff knows where to look before disseminating any information as it involves a minor or, for yet, an adult. This is just standard policies when disclosing any PHI information. When using a portal, it becomes much more complicated with a minor, and I'm going to talk through some things that we have encountered, questions that we've had, some ideas that we have. But in addition, when we get to the question and answer portion, I'm also going to hopefully see if anybody has any questions, but also if you have any comments or additions or other ideas, feel free to share those with the group as well. First of all, you need to get a full proxy access allowed for children under the 12 years of age. The parents have the ability to do that, that they can see everything. It's pretty consistent under 12 years of age, with the exception of, I believe, in Illinois for certain types of abuse. This is consistent. So if they're under 12, you have no issue. We pretty much recommend no patient portal access for patients between the ages of 12 and 18 years of age, because there's no way in NextGen to really control this from the standpoint of if they've given proxy to the parent, and then they have access, and if they have a certain type of treatment, how do you overcome that? How do you control that? We do have a few ideas, and I have had some groups that have went ahead and allowed patient portal access for parents. It's just something to keep in mind, and if we're going to make it safe, this is really the best way to do it, nothing between 12 and 18. Proxy access allowed for patients 18 plus years old only when the patient is in the office to sign and set up the proxy access for the patient portal. Many times you have students at college and different things where they're still allowing their parents to access their records. Make sure you have this documented and documented again. And I've even had in some cases where that's just not allowed, and it would be up to the patient to transition any information. Portal restrictions when access is granted. So patients under the age of 18, when you do offer the proxy patient portal access, sometimes if you went ahead and done it, you can restrict it to show only certain appointment requests. You may not want to show communications, medications, lab results because of the potential HIPAA violations if the patient legally could consent to any of these services without parent guardian approval. If you think about it, some of the slides that we've already went through, there are very specific things that patients can and cannot consent to without parental guidance. How do you in EHR say, okay, I'm going to give them access to lab results, but if they had an STD test, how would I control just that one test? And with the ideas of how we're doing this CDI communications and being able to download the records, it becomes almost impossible to segue that out. So if you do go ahead and give access to patients under the 18, make sure that you limit what you can share. And how do you reconcile this? I mean, obviously you've got patients, if you're in a pediatric office, it becomes a little bit easier because all of your patients are under the age of 18. If you're in a multi-specialty clinic, big issues in OB-GYN clinics, a lot of different areas. How do you reconcile this? Well, you start with a manual report reconciliation. You can manually run a report on the first of the month for all of the patients who are turning 18 during the upcoming month. Don't wait till the middle of the month. Don't wait until the month has gone by. Either do it a month in advance or at least on the first of the month for all of those who are turning 18 in that future month. Then decide as a practice which options are granted to minor patients and their families. For example, no patient portal access to patients under the age of 18. At age 18, patient access to the portal is granted based on the reports that you're running. You could also do no patient portal access to patients under the age of 12. And again, monitor that by your manual report reconciliations. And then at age 12, the patient's decision to share portal information with parents and legal guardians. If you're going to go ahead and do it, you must get it in writing and make sure they understand their rights. And at age 18, patient access to the portal is granted. You can go through different phased approaches to this. Again, going back to if we're looking to our recommendations, this is very, very difficult to manage. And until someone comes up with a better solution, again, always interested in ideas. The critical details, first of all, is to understand the laws of your state, and if not clear, follow the federal guidelines. Develop a clear internal policy for both EHR distribution of records for minors, and in that fact, distribution to any records. We're in a very automated area, and it's very easy for this information to escape these days. Develop a clear internal policy on how to handle patient portals, and make sure everyone is aware of and understands the policy. The bottom line is this is important to you and your special patients. Do you need help planning? Itentive can help providing an EHR workflow assessment to review your processes for not only minor medical records. We can assess your EHR workflow and challenges. We have some consultations that we offer, and if you're interested, we'll give you some contact information at the end. Right now, I'd like to open it up for questions, and in this case, as I said, I would really like some comments or ideas if anyone has anything to add.
Okay, the first question, will we be able to receive an electronic copy of this presentation?
Absolutely, and there's a lot of information in this. We spent a lot of time pulling together, particularly the laws, and it's very, I think, informative, and I hope everyone found it informative.
And on top of sending out the copy of the presentation, we're also going to be posting a recorded version of this webinar onto our YouTube channel later today. So if you want to rewatch it, you can find it just by searching for Itentive in YouTube. Watch it again and again and share it and whatever you want to do. Next question. Could you help direct us where we can find our state guidelines for Missouri?
If you will send me an email, I will have someone look that up for you and get that back to you. I don't know off the top of my head. We went to a lot of the Googling in Ohio. We went to just ohio.gov. That's typically where you can find a lot of these things. It varies from state to state. So if you will send me your email address, we will get back to you with that. And if we can't find it, we'll also let you know. I'll assign it to someone to see if we can't track that down.
Okay, we're going to wait for a few more minutes for people to type in their questions and thoughts. This really is an environment that we'd love to share ideas, anything that your practice has done, or if you've heard of other practices doing things, we'd love to hear them. So as you all are typing that,
absolutely, and even, oh, sorry, Chelsea, go ahead.
No, go ahead.
I was going to say, even if you don't have time to type it in this webinar or have anything to share, if you've heard of anything, always interested in viewpoints, and feel free to drop an email. The reason, this one in particular was challenging. I get a lot of questions about it. We have a lot of discussion points, work with a lot of practices on what works best for them. However, as you can see, there's no clear-cut and dry rule that we can give you and say this is going to work this way, or this is how you can put yourself out of risk in this. This is a very risky area, and it's a very important area. And as I said, it's also a very emotional area. I've seen the challenges that some practices have faced when conveying this information to parents, and it's hard for parents sometimes to understand that you as the practitioner have no control over this. And I'm sure as parents, and I'm sure there are parents on the call, you also understand the parents' viewpoint of how challenging this can be.
Okay, we got another question or a statement. We grant portal access to parents of patients under the age of 12. We have set that access to expire upon the child's 12th birthday. At that time, the minor can request a token to register for their own portal access, and parents must request a paper copy of any requested materials, must have the consent of the minor to do so.
That's excellent, and I think that's an excellent process. This is another area of discussion because I think you've covered it as well as you can. One question that was raised to me, and again, this is getting into discussions, is a child under the child between 12 and 18 still can be controlled quite heavily by their parents, and what if they're, somehow their parents are monitoring and they get their access and everything? I think you covered it to protect the practice themselves. It's just interesting discussions as to how deep this can go. I thank you very much for sharing that because that's an excellent process.
Okay, now we have a question. How can this be managed with the meaningful use requirements for 50%? We have practices that have failed meaningful use based on the PEDS population.
Again, you've got your challenge. I think the prior statement about maybe doing some work with 12 and under. I also think that there are, again, this could require some different discussions, and this is a good one because it's a question I don't have the answer to emphatically, because if you're a multi-specialty and you have a large PEDS group, that presents, again, a really strong challenge. I would think that what we could possibly do is come up with some rules in the auto-enrollment that would provide the credit, and maybe there are some ways around that, and I would be happy to talk to you about that. One example that I'm thinking of is that one of the meaningful use requirements is that you have to have made an attempt, and in this particular case, it could very well be an attempt to the patient, and you can have it there is no email address, and if the minor child does not have an email address, there are ways to get around it from almost an exclusion perspective, although it's not an exclusion. So I would have to talk it out in more detail. It's a challenge. There's no question about it. It's a challenge. And I wish I had, again, really precise answers for you, and I don't. I would be very interested in just having a quick chat with whomever issued that question.
Okay, next question. How does HIPAA define a confidential relationship between the minor and the provider?
I believe it's governed by the federal laws, that very first slide that I had, and if the states have something over and above it, I believe it's the same. I don't want to state that unequivocally. That was my interpretation when I was reading that. I'd be happy to research that again further. That's a great question as well. I believe it's that you meet the minimum federal mandates, because the confidentiality of any medical record is how it applies to the patient and what they're allowed to do. And I know under HIPAA, you are allowed to give certain information to the parents. I believe that it's the federal guidelines, but I would like to validate that specifically as it relates to HIPAA.
Do we happen to have a generic consent form where minors give their parents access to their portal?
I do not, because we at Itentive have not. However, I've got a couple of OB-GYN offices I work with that have shared it with me. With their permission, I would be happy to share that, and I think they would. I would just have to ask. Again, if you can drop me an email, I will let you know one way or the other if they will allow it to be shared, because it's very common practice in an OB-GYN office.
Okay, I think this relates back to one of your previous answers. How do you document exclusions in NextGen, if you're going to use it as an exclusion with, I'm guessing, the PEDS? Inclusions, it has to do with the email address, so you actually have to put in the email address, like attempt made. There were some things we found out last minute as we were rushing to get everybody qualified with a 50% measure, if that's what we're referring to. Now, there are other exclusions that I think there's been exclusion has been used a couple of times in this presentation. If you're referring to the exclusion that, let's say, for example, you have a particular visit, or something that the patient, you're treating the minor, they're treating for the flu, the measles, all of the things you typically do, and then the minor comes in and says they want birth control. That's also mentioned as an exclusion earlier in the presentation, and that you can do by either securing the encounter. There's some things you can do, but it's very manual, and it is very dependent upon human intervention, which can sometimes create a challenge, which goes back. So again, two different uses of exclusion in the conversation. I hope I've answered both of them the best I can. Once again, there's a lot of stuff here. I would be happy to talk to people about this quickly if there's other things that we could answer and just discuss through the options. I see that some more people are typing questions here, so while they're doing that, I just want to mention, again, we have that next upcoming webinar on February 11th, the Meaningful Use Relaxation Rule. Follow us on Twitter, on Facebook, friend us. That's where we send all of our updates, send links to posting them on YouTube. It's a great way to keep in touch with us and see what else we have going on. Okay, we got another question. What about step-parents requesting medical records?
I would say that unless a step-parent is a legal guardian, and I would say they have no rights. Again, this is my opinion, but a step-parent, again, using the term literally, a step-parent through a marriage, remarriage or something, I would say unless they have some legal governance over the minor, I would not say that they would have any more rights than anyone else. Now, in the case of a court-appointed guardian or something, that's one of the legal representatives. But if you go back to slide 6, which I can try to jump, I don't want to jump back through it now, but if you go back to the legal representatives, it was the parent, the legal guardian, and a court-appointed representative, I believe, were the 3. Step-parent was not mentioned.
Actually, Cindy, it looks like one of our consultants is on, and they submitted an answer for that one as well. That our consultant said they would need to have a court order proving that they are legally allowed.
Yeah, I think that's the same thing. So thank you very much. Whoever jumped in on that, because I know that we've had a lot of different research going on this one. An area of specific interest to all of us. It's very personal. This is very personal stuff.
Okay, so then somebody said, does the non-legal, hang on, let me read this. Does the non-legal parent, but is the parent, have just as much right to the child's records as the legal parent?
If they have a court-appointed, if they're a court-appointed representative, meaning that they're not the non-parent, then they would have the same rights as the parent because those 3 authorized representatives, categories of authorized representatives would work. Those that do not, again, going back to the step-parent, if they don't have any court-appointed, then they have no other rights than anyone else. It's really the legal guardians of the patient.
Okay, we have a comment. You can manipulate the lab results to only provide the patient with certain things, aka you can filter out the information for different viewers.
Yes, definitely, and that's an excellent comment, and that's one of the features of NextGen that you can take to a different level, and you can set up your filters automatically. Where I still run into challenges in looking, and again, this could be, I really thought this webinar would be shorter than some of the others we've had, and I'm so excited that everybody's participating. One of the challenges that I've faced in trying to come up with those solutions, and I think our team has faced, is that how do you the different phases? You're coming in, you're coming out. Now you could set specifically like lab results for certain tests and things, and that would perhaps be applicable to all of your patients, and that's good policy anyway. That's an excellent idea.
Okay, everyone. Well, thank you so much for your questions and your thoughts and comments.
Yes, thank you all. I'm very excited about the participation in this one. This was a subject that I wasn't sure would receive a lot of traction, and it's, as I said, it's very personal to all of us at Itentive, and making sure that now that we have the data and EHR is finally where it needs to be, we're just so pleased to be able to start looking at the data and looking at options for the patients and actually using the data that you have in your EHR. Now it's time to reap the rewards of all the hard work. For those of you who are starting to call it rewards, I know there's some still that don't feel so. That said, I appreciate all of your attending, and Itentive appreciates it. And Chelsea, thank you for moderating.
Absolutely. Thank you, Cindy. Thank you, everyone, for attending. Have a lovely day.